We'll be discussing on the topic of, so you want my public records? My name is Marty Foos. I'm a partner with Faruki, Ireland & Cox in Dayton, Ohio. I will be having our panel members introduce themselves here in a minute, but to give you some idea of what we're going to be discussing, imagine this is based on real life. The shootings up in Connecticut caused a lot of concern and inquiry into our gun permitting laws, and one New York newspaper decided that they would publish in an interactive map all of the gun permit owners, their approximate location on a map, the addresses and names. If you just hovered over it, you could see it. And there was some significant problems that occurred from that arose. And they ultimately, due to the public outcry, took that down. And that caused us to examine the question, well, when is something seemingly private, or it feels like it might be private, or maybe we don't know if it's private, but gosh, I don't know if I really want others to know about it. When does that get turned into a public record and then disclosed, and what problems result from that? So with that, I'm going to turn it over first to Professor Smith and have them introduce themselves very briefly. The full description of their background is in your materials.
Good afternoon. I represent the diversity on this panel. I'm the only one not from Dayton. I'm Professor Emeritus from Kent State University. Do you want me to get into the historical stuff, or should we go on down the line?
We'll go on down the line.
I'm Josh Swigert. I'm an investigative reporter of the Dayton Daily News. I also write for the Springfield News-Times, Hamilton Journal News, and Middletown Journal. And we're also in partnership with WHIO TV and WHIO Radio, but primarily I'm an investigative reporter for the Dayton Daily News.
I'm Pam Elliott. I am an investigative reporter for WDTN Channel 2 out of Dayton, but I'm from Columbus, and my father's here, so I just want to welcome him and all of you. Thank you for the privilege of joining this discussion.
I'm Joe Eaker, State Senator from Ohio 14th Senate District, which is Claremont, Brown, Adams, Scioto, and part of Lawrence counties.
And I'm Mike Sander. I'm a partner with Pickrell, Schaefer, and Ebling, and I work with Pam and channel WDTN TV2 with legal issues that may arise specifically involving public records.
Again, thank you all for coming. So the issue that spurred us to begin was the gun issue. And in relation to that, we have a proposal here with the Ohio legislature to address that situation in our state. And I guess I'd like to turn it over to Senator Eaker first to describe what the bill that he is sponsoring as it makes its way through the legislature.
I'll try to make this real brief. It's a very simple bill. It simply changes the portions of the Ohio Revised Code regarding the journalist exception to the public records law concerning concealed firearm permit. The legislature, when it created the concealed permits, originally had written that it was to be a sealed record, not open for the public, but because of political meanderings by then Governor Taft, there was this exception put in there. It was an open exception when it was first, law was first created, and because of several instances where journalists abused that privilege and published, hundreds, if not thousands, of records, whole pages of those who had firearm permits, published them in their papers en masse with addresses and phone numbers and all sorts of horrible things. And I think it was in 2006 the legislature narrowed that down and removed the allowance for them to copy. Then there was a lot of legal meanderings about what copying meant, but basically it had left it so that a journalist could go into a sheriff's office and memorize the names of those who are holding a concealed carry permit, and then write their stories about that. And it was once again what some considered an abuse of that, a story by a Hamilton newspaper a couple years ago where they listed the area elected officials who had concealed permits. And that once again reignited this the whole issue. And then of course, as I just mentioned, the New York newspaper recently who put a interactive website of all their firearm permits on the website for all to see. This kind of reignited again this year, and I submitted the bill that simply reverts it back, removes the exception, and reverts it back to its original intent to be a sealed, closed public record.
Before we move on to the broader topic as a whole, I forgot to mention that we do appreciate and expect questions from the audience. Even though we're far up here and on a pedestal, we would like to have anyone who wishes to ask a question, please do so, and all of us will respond. And we have our first taker.
Sure. I would love to speak to the CCW issue. Number one, I am a CCW holder and have been since 2004. But before I started law school, I was a journalist for 10 years. Part of the reason I felt like I needed to get a CCW was I did a criminal case story, and the suspect started stalking me and several other reporters who were involved in publishing the story. But as a reporter, I also had occasions where, I didn't go publish lists of CCW holders en masse because I was one of them, and I respected that right to privacy that, just because you have a concealed carry permit doesn't mean you want that information known, even though I don't care who knows about me. But I also had to cover an incident where a man shot his wife, and they were both CCW holders. And this is before the exemption was refined, and I was able to go in and find out that both of those people who were involved in a criminal incident as a suspect and a victim were CCW holders, and it was her gun. I mean, how would you, under removing the journalist exemption, if someone's involved in a crime, why can't a reporter go into the sheriff's office and say, hey, does this person have a CCW, if they make the claim that they shot someone who was invading their home or what have you?
There's a couple different ways to address that, but let me just probably stick with the concept that while it removes the exception, the law still allows for going to the courts and petitioning the courts for access to that record. So you will always have that, as you've always had that as a possibility of finding information if you can go to the judge and try to get that information. Now, granted, that's not the easiest thing to do, but the question still comes down to is there an overriding public interest in knowing what everybody has in their homes?
Well, I mean, couldn't it be refined even further to where you would go to the local sheriff with the name and say, is this person a CCW holder? And why can't it be simplified to that extent?
And that's the current. Okay, can I speak real quick? Actually, the Middletown Journal is one of the papers I work for, and they're the ones who did the story, the Middletown Journal and Hamilton Journal News. First off, to provide some context, it wasn't like they just wanted to let everyone know who had concealed carry permits. There had been a shooting recently in a public meeting, and there was a discussion at the time as to whether public officials should be allowed to be armed in public meetings. And so the context of the story was talking to public officials who thought they should be armed in public meetings. How responsible are they with those weapons? Who has a concealed carry permit? Within a meaningful context, not just here's all the people who have guns and where they live. So there was a justification for the story. At the same time, in order to even get that story, the reporter she couldn't just ask for a list. She has to go in, memorize, in this case, all of the elected officials in Butler and Warren counties, had to memorize all their names, go in the sheriff's office. Well, first she has to write to the sheriff's office, say that she wants to see the list, and that she's a member of the media. Then she has to go in and memorize the entire list. She can't write it down while she's in there. She can't take photographs. She can't record herself. She can't call somebody else and say, I found these names. She has to memorize everything she sees on the list and then walk back out and in her car, maybe write it down. If she forgets something, make another petition to go back at a later date. So the law is already exceedingly restrictive as far as who can access these and how. and making it more restrictive to solve a problem that the default should be on the side of transparency. The overriding public interest is transparency. So instead of asking why should we have access to this, the question should be why shouldn't we have access to this?
Especially in light of the fact that this, I'm not a journalist, but I'm a product of the media age, and that, you know, we've unfortunately had a lot of shootings and incidences in the news, and the first question that the public seems to want to know, or the first question that, you know, journalists seem to want to report on, is whether or not this person, you know, did have a concealed carry permit. And then the next question is going to be, and was there any background information reported to the NICS that would have, you know, indicated that they had a disability, or for any reason should that have been revoked? More and more, you know, especially now with school board members talking about, you know, which of them are going to be carrying, or teachers. It seems to be an issue that's going to be the subject of more and more inquiry. And, you know, to your point, if you just are going in one at a time with a specific name to request that under the statute, it is very limiting, I would imagine, in practice.
You have a question in front.
Senator, on your website, you talk about your beliefs in limited government. I think you believe strongly in that.
Yes.
Shouldn't government be accountable? And how does the press and the public monitor the activities of a sheriff who may be corrupt, who may be negligent, who may be handing out gun permits to people who have no business getting a gun permit, if that information is off limit to the public and the press, which your bill would make happen? How do we do that? How do we make government accountable?
We are required to repeat the question. So the question is, how do we have, I'm obviously summarizing a great deal, but how do we have greater government accountability when we are really restricting the public's right to access to these records?
Let me first talk about, for a moment, address what you had said about my belief in limited government. I first and foremost, I have a very serious question on, again, looking at our Constitution. Nowhere in the Constitution does it say that we're allowed to have firearms with a license, once a license by the government. So there's already questions to this already.
The First Amendment says Congress shall make no law restricting the freedom of speech. We have libel law, we have fraud law. There are limits on every right.
And
so,
you know
but go
what?
ahead,
But that's a
fine.
good point. But if we were just as adamant about our Second Amendment rights, this would not be an issue with the First
I think
Amendment.
we're pretty adamant about it. The NRA is pretty adamant about it.
But again, if we didn't have to have permits, it wouldn't be an issue at all about public records in this particular arena.
That's a different battle, it seems to me,
Yes.
Senator. If you don't want there to be permits, do that. If there are permits, then make government accountable for how they give them out. That's my question. How do we make sure that the government is accountable in handing out the permits? If you don't want permits, go get rid of permits. But if they exist, shouldn't the
So
government
how do
be
we make
accountable?
the government accountable? I believe we do already have a methodology for that. I believe the Attorney General's office does provide some oversight in this regard. And if you have a problem with a corrupt police department, a corrupt sheriff, then I believe that this would probably not be the only area that they're corrupt in. And I believe.
How do we test it?
Well, how do you test all the other exceptions that are in public records laws? I mean, look at all the things that are already, equally as protective or restrictive, and whether it's mental health issues, whether it's health, physical health, and all these other things that we already vehemently protect that make a lot of sense. I don't know. But you may have a good point.
Let's get to the broader question. We were thinking about this, and one of the things that struck me is how, we can change in our perception as to whether something is private or whether something is public. The quintessential example of that change for me was thinking back to a person's property values on their homes. Before the internet, that was something that we, or at least a lot or most of us, thought was our own business and not something that everyone in our neighborhood were supposed to know about. And then when all of those became available online, I would think that the vast majority of us did look at everyone else's property values, and we're okay with that. We've made it through, but that's been a complete change in perception. And so how has the perceptions, the realities of the internet age, of all of these, they're changing, and how has that come about? I don't know if the law has kept up in this area, and Tim, you were going to speak on the law and how it's developed here.
How many people here think they have personal privacy? Oh, good. Nobody put their hand up. With the advent of the internet, you have very little, and whatever you had left is rapidly disappearing. We put far too much information on the internet, and you can't stop it. There's just no way to even slow it down. Now, I do enjoy the senator's discussion of a closed public record, which reminds me of naval intelligence and jumbo shrimp. It's an oxymoron. If you have a public record, then it ought to be public. And if you look at the history of public records in this state, with the exception of the growing hostility by the legislature and the Ohio Supreme Court, we once upon a time did have public records. Back in the mid-'70s, we had a new statute adopted that basically opened up a lot of records that the Supreme Court had closed in 1976. 77 on, up and into the 80s, public records were largely open, and legislative attempts to adjust things came few and far between. And then that gradually changed to the situation that we have today, which is extreme hostility from the Ohio Supreme Court and fairly hostile from the Ohio legislature as well, constantly adding additional exceptions to the public records. In every Supreme Court case that deals with access to public records, it always starts out about these are the people's records and the people have a right to the records, but, and then it begins to explain why you can't have access to this record. You can't have access to home addresses. I'm a public employee. You want my home address? Look in the record. It's in the phone book. How many people remember what a phone book is? It's available. I don't care. You can see my entire record at the university that's available public. And I figure that's the cost of me being a public employee. I don't care who has that kind of information. Now, the senator mentioned people who you shouldn't know who has guns in their homes. I'm not worried about people who have guns in their home. I'm worried about people I meet on the street who are packing. Those are the ones that concern me. Those are the ones that these records would reveal. And I think if I'm out wandering around in public, I should have an idea of who's carrying. I'm not worried about the cops. They're trained exceptionally well. I'm worried about the private citizen who really wants that 357, because if I look cross-eyed at him, he's going to blow me away. That's a problem that I have. If you don't want your records to be accessible to the public, don't keep them. Don't take a public record. The senator's worried about having this information disclosed. I would think that anybody dumb enough to first find the address of somebody who has a gun in their home and is trained how to use it goes to try to break into that home, give me a break. That's like the police officers who say, I don't want my home addresses because I'm worried about somebody stalking me. How many episodes have you seen in the news in the last 25 years of people who stalk police in their homes? You won't find very many. It doesn't happen. That's not the problem with this law or others related to having access to public records. If the government doesn't want a record to be public, then it shouldn't keep it. It's a real simple way to approach this issue.
There are other examples of this shift when things that may have been thought at some point to be private are now in the public record realm that cause some conflict from time to time. And Pam and Josh, do you have some examples of those?
I just want to say a few things generally speaking. First off, I believe there needs to be a responsibility of the journalist to do something for purpose, not for pleasure or just interest or curiosity. I think that, I don't know that, I won't speak for Josh, but I don't even have the time to get the stories done I want to get done. I wouldn't just browse public records for the sake of browsing. I think you have to have purpose. I think there are stories behind the story. I appreciate your example. You know, a lot of times when there are shooting incidents, especially now, the question becomes, A, where did the gun come from? I mean, that's one of my most, I don't know, I find that very curious. I want to know, we had a situation where a mentally ill gentleman started firing in the middle of the day in Dayton, and police ended up shooting him dead. It was very disturbing for the police, for us, for the community. It turns out he had the right to the gun because he had gotten the gun. He wasn't allowed to have it where he was living currently because it was a gun-free environment for the mentally ill, but he had a family member who was keeping the gun for him, and then that family member started attacking us for doing the story. Well, the reality is there's always a story behind a story, and I think that we have to be responsible journalists in going after what is the real purpose in this story. And also we have to seek the truth, and that's what this is all about as far as I'm concerned. We can't get at the truth if we don't have, I rely on documents for what I do. I'm sure Josh does too. Without that, it's all a bunch of hearsay. He said, she said, and at the end of the day, we really don't know the truth. And if we're all about seeking the truth, we have to have access. We have to have access. You know, I consider it a privilege to be a journalist. I get at things maybe others don't have time to get at, or they don't, know where to go. And so I take that responsibly. I take that very seriously, that position. And I look at some of these on the outline of should we get it, should we not? Again, let's talk about divorces and marriages. And is it really my business who's married or divorced 3 times or whatever? It's not for a tabloid reason that I look at these things. It's for, again, access to information, but the truth of information. I've called people who used to be married to such and said, look, where do I go? I hear this about this, and I want to know. And you can get information from people. Exes don't always, have a problem giving up information. And again, would I broadcast it that evening? No, but it's a starting point. And again, if you're seeking the truth, it's just a matter of starting points. And you keep going, and you see patterns, real estate information. You look at patterns. You look at neighborhoods that are suffering. And how do you know they're suffering? Well, you look at their property values. And that's, again, part of a bigger story. You look for trends. That's what we're about, is finding out where the real problems are in a community, who's solving them, what are the solutions. That's my input on that.
Yeah, there's an ideological aspect and a practical aspect. I mean, the ideological aspect, which you touched on, was these are the public's records. They own these records. The premise of democracy is the public is smart enough and wise enough and responsible enough to oversee the government. And when the government says, you can't see that, just trust us, that undermines the entire premise of democracy. But these are records that the government keeps for a reason. The government decided we need to keep track of this, and whatever compelling reason the government has to keep those records is the same reason the public has in wanting to know what they're keeping and making sure they're administering that properly. On the practical side, there are lots of ways in which these stories have been used. I mean, this information has been used. I think looking over here, we have personnel files of public employees. That's one of the things that's mentioned. I use those all the time. If it's not uncommon at all for a public entity or public employee to get in trouble for doing something, to not get disciplined or to quietly leave, and then we get their personnel file and find that they did something possibly even criminal, and they got a job at some other public entity that didn't even know what they did. I could probably give you 3 stories off the top of my head. With looking at personnel files of public employees, we've done stories about nepotism, about patronage, about public employees who got jobs that they shouldn't have got, about the fact that a public employee got a job that no one else was even given an opportunity or applied for, how much they're paid. Public employee X got a 50% pay raise over a couple of years, though they stayed in the same job. And that actually gets to marriage and divorce records sometimes too, because nepotism and patronage, I've done stories about those which divorce and marriage records allowed us to find, yes, this person is married to so-and-so and got hired to this position and was able to increase their pay. In this case, I think it was a county administrator and his wife in Butler County. And her pay went up, shot up for several years. There's an ethics commission investigation. They resigned. I can just
Well,
go ahead.
can I say, too, in the matter of balance and fairness, I mean, in terms of personnel records, a lot of times it's not just to point out the failures of this particular individual. We were looking at a trooper being investigated currently in a crash, and we wanted his personnel records not so much to point him out as a bad employee, but the fact was he was a stellar employee who may have had one bad move here. It's not always to make people look like they're not responsible or they can't do the job or they should have never got it in the first place. A lot of times it's just to provide balance. As an investigation unwinds and we really don't know the outcome.
You know, and Marty, you had asked, you know, you started this with an observation about the perception or a shifting in perspective. And I think it's important to note that a lot of this information isn't something that's only recently become a public record. All that's changed is technology has facilitated the way with which we can access it. I mean, property records, divorce court proceedings, those things were always down in the courthouse, but seldom would a person off the street want to walk down and take the time to do it. What we've got now is this convenience where on Tuesday I was walking around Murfield and someone asked me, do you think there are any homes here under $500,000? I don't know. Let me hit the Zillow app on my iPhone and hey, yeah, there's 2 for sale over by hole number 7. So, I mean, it's an access issue that I think probably, and I'll defer to the reporters, you know, aids to what you can do with a story and how quickly you can get the information out.
One of the access points that people that I speak with are always surprised to hear is, you know, there's available on LexisNexis a certain product that allows you to do some background review of individuals, and there's limitations on what purpose I can use it for, and so I have to make sure that I only use it for certain things, and those have to do with litigation, which is what I do for a living. But when I'm, you know, looking at jurors, for example, or trying to find out about a particular witness, I can get, you know, voting records. I know which primary they voted in, whether it was Republican or Democrat. I can get the divorce and marriage records. I can get where they live and the property value for their home, any auto or car or hunting licenses and what kind of vehicle and all of that information. And then what's really astounding is it starts to compile that information, and then through algorithms and the whole 9 yards starts to make predictions as to who they're related to and what their likely income is, and you know, and it's one of those things that's taken all from public sources, but it really starts to delve fairly deep into a person's life. It still doesn't necessarily help you make that decision, which you have to make in 3 minutes or so as to a particular juror, but it does provide a lot of information that people don't realize is there. And this calls really, I think, to question, you know, how can we conceptually deal with this situation? We've talked about purpose a lot, but we all know that if we start delving into people's purposes for asking for this information, it runs into some big problems pretty quickly, and yet it seems to be at least relevant. And so is there a way to deal with that? Is there a way of trying to understand that in the law? Any comments on any of this from our panel?
It goes back to the basic ideological point that these are the public's records, so almost entirely the purpose isn't. Again, we shouldn't be asking why do you need access to this? It's why shouldn't you have access to this? Because we can't anticipate what the need will be as it arises. But yeah, beyond that,
I mean, I agree with Josh. I mean, if we pay for it, if we fund for its compilation and retention, why shouldn't I be able to see, you know, what's being done or what the information that's being compiled and retained is?
yeah, this is the work product of my tax dollars.
That's right.
So then there should be no exemptions at all in any way, shape, or form, in any manner? Is what I'm hearing from you?
There are times when we can all get together and decide that there might be an issue, and we can choose to exempt it because there's a danger in its public release. Not because it's not needed by the public. And if you can point to an example where public records were used to identify someone as a concealed carry permit holder and that made them more endangered, I'd love to hear it. But at this point, making a law to the assumption that something bad might happen is guessing. Yeah, it's trying to legislate possibilities, it's trying to legislate theories instead of actual examples or things, saying something went wrong, therefore we have to fix it, as opposed to fixing problems that don't exist.
The problem with a lot of exemptions, and no offense to the senator's proposal, is that a lot of them are knee-jerk reactions to very specific instances. I believe, is still pending in the legislature a bill that would make dash cam footage shot from a cruiser not a public record if it captures the shooting of an officer. I think there was one example of this in northern Ohio a few years ago, and that's what prompted this change to the bill. It's such, again, you were talking about, people stalking police officers. This is something that's very rarely seen, but, you're taking something that's otherwise certainly a public record. You've got a camera that taxpayers have paid for to preserve images. And, who watched the news this morning? There was a shooting where an officer was shot that was, right on the Today Show. His shooting was not on the video, but it's that same sort of instance. And you're anticipating that the news media, I assume, is not going to have the judicious discretion not to perhaps air something that's overly graphic. And so, I think those are the concerns when we get into specific exemptions.
We've had a gentleman with red hair back there who's been waiting, so I'm going to go with you first. Yes.
I was just interested in hearing, I know that the journalists and advocates against the bill have said a lot, but I'm interested in hearing the senator's rebuttal to some of these criticisms.
You want to hear some of the criticisms?
Rebuttal.
Rebuttal to some of these criticisms that have been leveled against your bill.
The question was, you'd like to hear more from the senator in rebuttal to the points that have been made.
I think I pretty much already made those points, both in my opening and in my comments. I think once we get past the hyperbole we heard up here already and the obvious journalist bias against gun owners, I think what you have left is we agree that there are some cases where public records do serve a purpose to be open, but we also have admitted up here that there are some cases where it does not serve a public interest. So, to sit there and say, either you're for all of them or you're for none of them. I'm not sure that's not what I'm saying. That's not where I think we should be. But again, we're just trying to reach some middle ground here. And here is a law that specifically was created to be a closed record.
I'm just interested, could you cite a documented example of journalistic bias against gun owners?
Dahl.
Back in the back.
Okay. His bill is not devoid of reason. When you have the list of gun owners, you've done two things, both are bad. One is you create a shopping list for those who would like to steal them. The second thing that you've done is you've created a list for people that want your jewelry and stuff of the safe places to hit. So the last place I'd want to be is in a house where, on a street where there's 10 houses and 8 are on his list and 2 aren't, and I'm going to live in the 2. It's the same as those really cool signs that keep us all safe if we don't think about it, that on a business decision, there's no concealed carry here. What that sign really does is tell the robber, the thief, whoever it is, you're safe in here. You bring your gun in here, you own the whole place. It's a rob me sign is what it is, because it says you are safe here. And his list, if you're not on the list, you are probably a safe place to go get your jewelry. If you are on the list, then if the bad guy's interest is in guns, then you've created a shopping list for him. Now you can weigh and balance the things you guys have been talking about against that, but the other side is not devoid of reason. There is reason, and the newspapers. And I know we got reporters here, and I'm going to upset you here, but somebody asked, well, show me an example of some newspaper jacking around gun owners. When they publish the list of all the gun owners, that's what they're doing. They're yanking around the gun owners. That's why they do it. You don't get some Republican-owned newspaper doing that. You get, the other leaning newspapers doing that.
It would be physically impossible to do that in the state of Ohio.
Okay, but it's been done in other states.
No, it was done here in Ohio by the City Daily News.
When?
The year that the law was passed.
Right, now, I mean, now it'd be
But
physically
yeah,
impossible to do that in
It would be
Ohio.
physically
I got
impossible
a
now, but
point
Sydney
to make.
Daily
I'm not
News
done
did it in 2005.
So right now, it'd be physically impossible to do
And
that.
I'm not done yet. And in terms of the people who are not on the list, we have all seen those cases in court where some gun person puts up a sign in his yard that says, "My neighbor doesn't believe in private ownership of guns, and I promise not to use mine to defend him." And then the lawsuit's about, take that down because that puts my home at risk. We've all seen those. Okay, the list he's talking about is like a whole bunch of those signs. So if you're not on the list, it subjects you to a risk. If you are on the list, it subjects you to some other risk. And like I said, you can weigh and balance, but the other plate is not devoid of reason. There is reason to do that.
Can I ask?
Yes.
Can I ask a question of the two up here? All of the shootings that occur in your area and all of you have investigated, do you routinely go to the sheriff's office and find out if those, either the victim or the perpetrator were CCW permit holders? And if so, have you ever found one that was? Because again, I know so much of what we're talking about here is somewhat anecdotal because it's very difficult to come up with an example where a burglar decided not to go to a place because he read a story where that person's got a gun in the house. I mean, how do you have record of that? But I mean, in your particular both cases, all the investigative work you do you routinely do that, or have you done it before?
I do not routinely do that.
Okay.
No, I don't, I've not covered crime in a couple of years, so honestly, I don't know if our crime reporters do that. I know I've seen in stories where we pointed out that somebody was or what, well, okay, I don't know, I don't, but I don't cover crime, so.
And again, I think that when you look at the actual numbers, you know, there's probably over 80,000 CCW permit holders in Ohio, and yeah, I'm pretty sure that no one's going to print that whole list under current law. They probably weren't going to do it under former law either. It's a lot of pages. And there's probably, conservatively, half, maybe even equal to that number of people who have chosen not to get CCW permits because they know that that information is open for public record. So, you know, no one has ever thought to look at from that particular case of it's inhibiting people exercising a constitutional right. But I think what we hear here, it's really not that big of a deal for people to think that every time there's a shooting that we want to rush right out, and everybody wants to rush right out to find out who in that party has a CCW permit.
For perspective too, just, you know, in case people want the temperature of the country, you know, we had looked, and there's only one other state, or one state I should say, that has legislation that dictates that the CCW permit information is public. The applications are not. There's 28 states where that data is prohibited. So,
Right.
Yeah, it kind of.
This is a new ground.
Yeah, just.
We'll come back to you in a minute. The area is broader than that still. We can think of situations where we have red light cameras and the video that comes from that, or the snapshots that come from that. You know, that's, of course, some picture taken in a public street. And so, you know, that appears to be something that's very public. But then we start getting into all the camera shots of the license plates that aren't done for a purpose of investigating a very particular crime, but rather are taken in case they may want to go back and search those records later. In Dayton, we had a situation where the city officials were thinking of hiring a surveillance company that would fly a plane over the city nonstop, taking overhead camera shots of the city, and then storing all of those images electronically. The thought being, well, if we discover at a later time that on Sunday, March 2nd, there was a robbery at such and such location, we could go back to those picture, look and see the van leaving the location, and then following where it goes, and that's how we could go ahead and track down folks. Are those public records now? Can we have a situation where a disgruntled ex decides to use it in the divorce proceedings if they subpoena it? Are there, so these issues I think are going to keep cropping up where something that it's not as necessarily private, although sometimes it might be, but it feels very invasive if anybody has access to it. So.
The red light camera issue, I can actually speak to that, because we did a story about a year ago where we got all the city of Dayton's red light camera footage, and we looked for examples where the reason for not giving a citation was listed as emergency vehicles. And we looked at the actual videos and determined what percentage of those were ambulances and firefighters and police officers not responding to an emergency, just running a red light. They're only allowed to run a red light if they're responding to an emergency. And so that was an application of those records and with the purpose of public accountability.
I'd like to provide some reassurance for the gentleman in the back who raised the point about no concealed weapons in these premises. I own guns. I have several in my home. I don't have a CCW permit because I don't feel compunction to carry the gun. I also have an office. And although I don't, I could keep a gun in my office without a CCW permit. The permit only allows me to carry a gun on my person wherever I want to be. And that sign says, if I got one on my person, stay out of this location. So you don't have to worry about staying out of stores that have signs up saying no CCW here. The store owner can own a gun. He can have a shotgun under the counter. He just can't carry it around outside. But he can have all the weapons he wants in that store. That's not a problem. It's carrying them on your person that is the thing that the permit allows you to do. Not in your home, not in your store. Those areas, you can have all the weapons you want.
I hear everything you're telling me. If I'm going to rob a store, one of them has a sign that says no guns, and one of them doesn't. Believe me when I tell you, I'm going to the one that says no guns.
I'll watch for you.
I'd like to just comment a minute on the Newspaper Association's concerns about Senator Eager's bill, and we've had some good, healthy discussions about this. One is the Police Chiefs Association also is concerned about this bill, just as an aside. But one of the problems that's come up around the country in serious investigative reporting that's been done, and it kind of goes to what Jack was saying about the watchdog role, there's a disconnect in many cases with sheriffs being informed that someone convicted of a felony in another jurisdiction may no longer be eligible to have a permit under Ohio law. There's certain people cannot get these permits. And if we can't perform our watchdog role in assessing, you may get a tip that there's convicted felons, may have moved to another county, they're obtaining permits. I mean, that's a very legitimate story, I would argue with a good public policy purpose. So the restrictions in the law now are so narrow, it would be impossible, to Josh's point, to run that full list like happened in New York, even if one wanted to do it. To completely deny journalistic access to this literally eliminates our ability to independently be the watchdogs that we're supposed to be. And as the reporters have indicated, it's very rare that these inquiries even occur in Ohio because the law is so limiting and narrow. So, we would argue that it's kind of a problem in search, a solution in search of a problem. It's really the way it's at now, I think, protects those concerns that permit holders have pretty thoroughly in all but the rarest of cases.
I think often in this realm, in the world of public records, we miss, we focus a little too much on the trees and miss the forest. The idea that, people want to see specific permit holders, and I kind of want to get out of that realm. Let's a few years ago, there's big controversy in Florida about the Dale Earnhardt autopsy. And laws were passed in some states limiting access to autopsy records. It seemed like an invasion of privacy, and I get that. But one of the motivations for the search for those records was there was an issue about whether NASCAR was enforcing a particular safety device on cars. Race cars were supposed to have this particular safety device, and lots of drivers apparently were not using it. The autopsy photos had a bearing on that, and they shed light on whether Dale Earnhardt was complying with this safety requirement. It was not some ghoulish, exploitative desire to see his autopsy photos. It was a legitimate issue, if not public concern in the NASCAR community, which in some places is, most of the community. And I just think sometimes we, as a lawyer, and I think journalists, we don't probably do an effective enough job of explaining the bigger issue and the watchdog role. Ohio allows for applications, resumes of unsuccessful applicants for public positions, that those resumes are public record. And some people think, oh my God, that's a terrible invasion of privacy. But the bigger picture is, how do you know that the process was fair? How do you know if the process was non-discriminatory if you can't see the unsuccessful applicants? If all you can see is a resume of the guy who got the job, what can you determine about the process? So again, it's not this salacious desire to see a particular piece of information. It is the process. And just a final point, and I'll shut up, but in an open society, we accept unintended and bad consequences for things we believe in. I mean, we have the First Amendment. And so because of that, we allow terrible, bigoted people to picket at military funerals. We don't like that. We don't like those people. But we like the First Amendment, and we recognize that we're going to have to live with that. We have a Second Amendment. So despite the slaughter of 26 school children and the fact that our country leads the world in gun-related deaths, we respect the Second Amendment. Fourth Amendment. We don't like the fact that a criminal can walk away because the search wasn't properly executed. But we live with that. And we live with that because the overriding issue is that valuable. And yet, in Ohio at least, we see the Public Records Act just cut away. There's 29 exceptions. There's not enough letters in the alphabet to accommodate the exceptions.
The Public Records Act is certainly, we can all agree that there's very few overriding principles anymore. It's as you were explaining, it's grown to be, very, very narrow exception, but then on and on and on and on and on and on and on. Is there a way of getting back to any core principles that could be applied more generally? Is there any way to get away from the piecemeal way that we've been doing this?
I'll just stay. I might be standing alone here as I look at all of you, but I am a broadcaster. I've been in television now 30 years if you count being a student as well, and video is everything. I mean, that's for us, video is everything. So when you talk about access, it's great that you can go in and you have a reporter, Josh, who can memorize names. I can't. My memory isn't good. I have to take pictures. I have to take notes. That's what I do. And I think access, the video, you have to understand, we deal with this every day. What's appropriate, what isn't appropriate, and a lot of times, and Mike can speak to this in a specific case of some dash cam video we couldn't get initially, and we got it. But the point is, I think we have smart viewers out there, and I want them to see and make their own determinations. I'm not an expert. I'm a relayer of information, okay? I'm a writer. I've learned a lot, but I'm not an expert of anything. And so I want my viewer to see what I'm seeing and decide for herself or himself. I worked in the state of Indiana, which still does not have cameras in the courtroom. And I came here, and I couldn't believe it. I mean, I could come in with a I mean, how much better for the viewer to see and hear the testimony firsthand instead of a reporter talking about what he or she heard and saw. Yes, you can get the court records, but usually not right away, okay? So by the time it hits air, you're going on what a reporter saw and heard in a courtroom versus the video, which here in Ohio we have access to, and we can shoot ourselves. How much better for the viewer? And for the general public to make those decisions on her own or his own. I mean, to me, that's what we have. We have a privilege here to present the information. But at the end of the day, I'm not going to tell a viewer how to think about gun control. I'm not going to tell a viewer how to think about an incident that occurred. I want the viewer to have that opportunity, and that's we're providing a service. I believe it. Maybe I'm a purist that way, but that's what I believe. Mike, do you want to speak of the issue on the dash cam?
Well, I mean, and this goes to sort of the timeliness, but, you know, when we've got an act that has exceptions, and there always being a fear of how the obtained video is going to be used, you know, what Pam's referring to is we ran into a situation, and we've all seen the dash cam footage of someone sideswiping a trooper's vehicle on the side of the interstate. You know, some graphic incident captured on dash cam footage, whether a Supreme Court justice's DUI. All these things are routinely turned over like that. We had a situation recently where it was a state trooper that rear-ended someone right from behind on State Route 35. And that, for some reason, no one wanted to turn over. All of a sudden, that was going to be a confidential investigatory record where, you know, never previously had it been. So, you know, yes, we got it, but the time delay of, you know, playing hot potato with the video, well, the prosecutor has it, no, the Highway Patrol has it, no, we gave it to the Department of Transportation, you know, you file a suit, you get your writ, and then they turn it over. You're 2 weeks after the fact, and it's lost some of its oomph. So, I mean, video is everything, but at the same point in time, I think there's usually a much more perceived fear than a realistic fear about whether what is aired is going to be improperly used or given improper context. At least in my experience.
Well, and to address, Marty, something you brought up, I mean, again, I think we have to, again, be responsible journalists, and a lot of times we will go on the air, and people can accuse us for maybe ratings and tease factor and all that, I understand, but a lot of times I know our management will want us to present a warning of some sort that this video may be disturbing to some folks. Also, I think we don't over-tease it. Our managers, I know, even the newest, they're like, don't keep using that video just to use it. Use it with purpose, again, make your point, let the viewer decide, but not to overuse it. The web, though, that can hurt because it's used all the time.
I'm going to inject the idea of purpose again, and again, I don't think that's the answer here, but in some ways, it started to infiltrate our law again, and one particular situation involves the motor vehicle licenses. Again, this is motor vehicle information. It's not private, although when it's sold for purposes of commercial entities who want to use the list to make solicitations, it does feel invasive. And Mike, could you describe that situation for us?
Well, I think there's some emerging discussions that, you know, I haven't seen too much of in Ohio, but your driver's license information is not a public record per se, and that it's not supposed to be disclosed except under limited circumstances, but one of those circumstances allows the registrar to share that information with a legitimate business. No doubt a well-intentioned choice of words, but exactly what constitutes a legitimate business, I suppose, is at some point going to be ripe for discussion. And what you're seeing more and more of is people getting concerned with not so much the public records aspect of it, but how that information is being stored and retained by those legitimate businesses that do get access. there was a class action suit brought in Florida, I believe, against Best Buy. Someone went to return a computer mouse that they had purchased. They swiped the driver's license, and he says, "Hey, what are you doing that for?" "Well, we got to make a record of who you are, how many items you've returned." And he says, "Okay, now delete it." "Well, we can't." So he brought a class action suit claiming that that had been an unprivileged disclosure of private information. Court threw it out, saying that the registrar hadn't released that information. He did by handing over his driver's license. But that's the situation that you see repeated around the country at Targets and Best Buys and other stores like that. So I don't know if anyone's seen anything like that in Ohio, but it's certainly another area that as we go down that road is going to become more and more the subject of conversation. First of all, because of the ease with which that information can now be recorded by swiping your driver's license, and secondly, now that merchants have the ability to retain and store that data.
And so you can go online and get driver's license information for yourself, for example, but there are limitations in the law for commercial entities that want to do that wholesale. Yes?
Background on or perspective on where purpose even entered into the conversation, because as I recall, it seems to be what has been used to chip away at what was originally a very matter of fact open records law that said just about everything is open, and which is the way Ohio's law originally was. How did purpose enter into the conversation legally to begin with? Because it shouldn't matter, and it wasn't part of the original law.
The
The
question
question
was
is, how did purpose get into the law? How is the reason that you want a record suddenly part of the law? And it got in largely through the Supreme Court. The legislature didn't add that. The Supreme Court began to find some very uncomfortable situations of cases that it just simply didn't like the way people were going after information. One of the more pronounced ones was in Columbus, where some guy wanted the information from the recreation department about all the kids who had signed up for citywide recreation programs. And the city was keeping the name, the address, the phone number, parents' number, all that kind of information. This guy said, "Give me that information. It's a public record." Undoubtedly, it was a public record. There's absolutely no question that it was a public record being kept by a public entity. Supreme Court took one look at that and said, "Boy, this is a bad one. We don't like this." "What do you want that information for?" "Well, we can't give that information because it's not an appropriate purpose. That information's not being kept for some governmental purpose." What other reason was it being kept for? It was being kept so that the city recreation people could find the kids' parents if it was a problem. But the Supreme Court engrafted sort of a purpose-type clause, and they've done it on other cases as well. Why do you want police information? Why do you want their home addresses? It doesn't make any difference because the statute doesn't provide that, but the Supreme Court has added it to the language of and as case law, it's as good as the statute.
And of course, later developments in the law then now includes that as an exception to the Public Records Act. And so now purpose doesn't matter anymore. Now that it's always prohibited from disclosure. And that's the trick is how do we take something that involves particular situations and press that I think most of the time, the vast majority of the time, is doing it for an extremely legitimate purpose and make those calls. Sometimes it feels like we make a call too far one way, and sometimes we make a call too far another way. But we're trying to stay away from a purpose inquiry because that's a very dangerous proposition. There are some other issues that come about between this difference between private and public, and Josh, that has to do with the privatization of public functions. Could you speak to that?
Yeah, this was touched on also. One of the other issues, they talk about Jobs Ohio at length. I have personally more experience with charter schools, and I'll just give you my experience. The charter schools have blown up in Ohio in the last few years due to reforms with the legislature. And charter schools, at least in the Dayton area, there are several that all the money comes into the school. The school board then has a contract to manage the school, and these are big in Cleveland too. So 98% of the funding then goes to a private entity that manages the school. They employ all the teachers, they own the buildings, they own the administrator. That other 2% really just pays for like coffee and donuts for the board meetings. So in essence, we have a school, an entire school district that is privatized completely to the point that we can't get teachers' personnel records, we can't get how the money's being spent, we really can't get anything because it's a private business that is, in essence, a school, and that's been a development. I know that's being litigated, I think, through White Hat Management, and I think that's, I don't know if anyone probably knows, somebody here probably knows more about that than I do, but that's still in the works. Some school districts up there that are trying to find out how much the schools run by White Hat Management, how they're spending their money, how much of their money is actually finding their way to children, and how much is finding their way to for-profit institutions. And there are school districts that I've dealt with that actually stopped becoming nonprofits because they realized that the more information is public, and they started becoming for-profits, because there was a mistake to originally even become a nonprofit, because then they had to disclose how much their administrators are paid and that sort of thing through the IRS. So they switched over to being for-profit institutions specifically so they wouldn't have to disclose such information. So anyways, that's just an example of one of the move towards privatization. I think Jobs Ohio was discussed earlier, and there's probably lots of other examples. Anyone else?
The case law here imposes a functional equivalency test asking whether or not they put in, whether they perform a governmental function. On the ground, and I'll open this up to those in the audience too, on the ground, how is that working out right now? What I mean is, how are you finding that that's, are you...
There are instances in which organizations, I mentioned the red light camera issue earlier. Red light cameras in most of Ohio are managed by a company called Redflex. Redflex is a private entity out in Arizona. They actually keep all the footage in a database out in Arizona. So we asked cities for that, for the actual videos, and they said, well, they're kept by this private entity. We said, well, these are your records being kept by a private entity. We still want them. And the city complied and handed them over, and it was a complicated process because they had to like mail a FireWire drive. But so yeah, there are instances in which it has worked. There are obviously, more often than not, that argument has fallen on deaf ears. I struggle to think of too many times where that has been a successful argument, that you are doing a public function. There's been more examples I can think of times that hasn't worked than times that it has worked. But there are some. That's probably one example. I mean, there's lots of instances where, I think this is mentioned, the last thing is also where private entities keep the records for a public office. And they generally have acquiesced that, yes, we realize these are our records that we're just keeping somewhere else, and we'll get them for you and hand them over. But if they're having if there's a for-profit entity that's actually managing a function of it or a piece of it, then that's been, yeah, not very successful.
And any experiences from those in the audience? Yes, sir.
I think it's restricted access to public records on the whole. The functionality test with 4 factors. Is it a traditional government service? Is it primarily funded by the government? But then the third one is, does the government retain day-to-day control? And the whole purpose for the government delegating to the private entity is to not have to do day-to-day control. So, I mean, it's almost like a self-fulfilling prophecy. So that's the Supreme Court, the Oriana decision. And I think that I think it has restricted access greatly.
A lot of people, one example people might not realize is the DMV offices across Ohio are actually private entities. And you have the vast majority of them are privately contracted out. You have no idea how much the BMV employees are making, how much of a cut the people who have that contract are taking. So while you're standing in line, you have no idea how understaffed they are for the purpose of maximizing their profits. Because we tried to figure that out actually about 3 years ago. And Ohio Department of Public Safety said that's all their dealings. We just paid them the money. It's a contract that's awarded by the Ohio Department of Public Safety. So BMV offices, that's another privatized.
Yes.
We had a case again in Dayton where a police officer was being investigated, internal investigation. We went and asked the police chief for phone records of his publicly financed cell phone, and they said, well, we don't have those. And I said, how do you not have your own phone records? And they said, well, Verizon asked us if we want the call-by-call or just the bill. They said they had just the bill, so they don't maintain the records, therefore they don't have any numbers that the police officer told them.
Yeah. And this is an example of the ever-changing nature of these things. The things that you think start off as being maybe they're private. We've grown accustomed to, for example, public employees and their personnel records are now public, and we know that now, but that's probably a perception that's changed over time. And then we have government that's privatizing more and more, or deciding not to keep records that it would have kept in the past and making more and more private. And it's constantly jockeying for position there. Any other
You can see it happening
experiences?
in 3 spots here, and it's worth watching. We're looking for 3 university presidents: Ohio State, Kent State, my university, and Cleveland State, all looking for brand new presidents. And each one of them has hired a search firm to do the legwork for them. And all of the search firms work the same way. They collect all the resumes, they pass them around to the members of the search committee, and then they collect them again. And they take them back. So that when you go to ask for the records, I'd like to see who's applied for this job, sorry, we don't have them. Now, it's the only time I've encountered in the public records area that people, public officials, get information and then give it back. No place else in this government do I know of where you can collect a public record and then return it to somebody and it no longer exists, at least not in the public realm. But search committees routinely do this because the universities all maintain, well, you can't get good candidates unless they can do it all in private. That's nonsense, but that's the argument that you get, that good people won't apply if they can't be kept secret. Good people don't have to worry about that.
I would just say there's great inconsistency that I can see, and that's troubling. Depending on the department, depending on the county, depending on the prosecutor, and I've only been working in the Dayton market for 4 years, but my experience has taught me that with certain people I expect it to be difficult to get at records. Other people I expect to work really hard to get them in a timely fashion. I don't know if the senator can address why the inconsistency, and is there anything you think you can do at the state level to make it more consistent?
Wow. Let me just say that the legislature is constantly, believe it or not, trying to balance the public's right to know versus protecting Ohio's citizen information. If I could say that, my bill here that we're talking about was predicated by a group of citizens who came to me with the problem that they would like to get a concealed carry license, but they're afraid to because they don't want their information being made public. That's a very real concern that a group of citizens brought to me. They brought it to me 8 years ago. I've been spending all that time painstakingly trying to determine how to do this. The bill went through 4 redrafts, totally, radically different each time. I can't do this, can't do that. This is the one that we settled on. I settled on, and to bring before the committee and the General Assembly. These are very difficult topics for us. I think of all the sessions and the caucus arguments that we've had over the years, by far and wide, the majority of them are over these types of issues. And there's other issues that we just kind of touched on ever so briefly here. The red light camera footage, the speed camera footage. One that wasn't brought up, the forward reading license plate cameras that are in some of our highway systems and being installed in some of our police cruisers. A very real good public safety subject that they do serve. Question is how long is the government going to hang on to those records? 30 days to find out if bad boy Johnny was over in that area of that burglary or that homicide or whatever. We can hold that information for 30 days. We can hold it for 90. We can hold it ad infinitum. We do have the technology to hold all of that, so that every one of those police cars or overhead highway cameras, they're taking pictures of where you are at any given point and that can be, searched in a rather large database. We're dealing with those issues. The drones, that information, this is stuff that, boy, 8 years ago, who would have thought that the technology would have gotten us here? And who knows where we're going to be 8 years in the future with technology? Answer to your question, I have no idea. Where each one is taken topic by topic, issue by issue, and point by point. I do have to go back for just a second to the professor's comment, because I see this in my own community, where small government groups, government entities are trying to skirt the public records for what they consider to be a good problem to try to get around. Frankly, I'm not a good poker player. I don't play poker at all because I don't have a poker face, and you probably all have seen my eyes light up when that comment was made. Of course people are going to decide, I may be the best superintendent of this school district, and I want to work my way up a little taller to this school district over here because the money's better. But boy, if my school board finds out I'm looking, then they're going to get rid of me, or it's going to affect my contract this year or next year. I mean, come on, those are real common sense things. We all know this happens. How do we deal with that? I don't have the answer, and obviously no one else in the General Assembly has the answer either, but we keep fighting it and keep trying to deal with it on a case-by-case issue.
Last comment.
Can you just name one person to support that? I mean, that common sense thing, just some evidence of that happens? Just by name? Do you have a name?
Oh, come on, no. All right, okay, so if it's not real, it doesn't exist. I understand that.
Any last comments? Well, I want to thank you for your kind attention. These are obviously issues that we can't solve in one session, but they are all constantly changing, and we all need to grapple with them. And thank you for doing that with us for just over an hour today. And thanks to the panel.